Our next speaker is going to be talking to us a little bit about contracts with commercial real estate. He is a partner at Venable and is touted for his ability to handle complex real estate transactions. Locally, Kevin Shepard has been recognized as one of the top 50 attorneys in Baltimore, and he's been named one of America's leading real estate attorneys. He has been named internationally by the International Who's Who of real estate lawyers as a thought leader and the most highly regarded individual. I would like to welcome Kevin Shepard up to the front.
Good evening, everyone. I have 3 strikes against me before I even get started. One is you've had dinner already, it's getting late, and you have to listen to a lawyer. You know, what can you do? I'm going to talk about commercial real estate, and some of my points in this presentation will focus on income producing property. I know that you may run into that from time to time. It's not your primary focus, but I do want to sensitize you to a couple of issues that tend to come up in that area, and I think they may be of value to you. The first point is, well, this is going to take forever. Let me just get them all down here. The money, the economics, that is so central. Every deal deals with money. That's the bottom line. That's the currency of the transaction. It's easy to get lost when you're dealing with a contract that goes on for 30, 40, 50, 60 single-space pages, and you're getting lost in there. A lot of people think it's mumbo jumbo, but every provision in that contract has an economic consequence. What do I mean by that? It's shifting the risk. Someone's ox is being gored in every provision in a contract. It may be subtle, it may hit you over the head, but keep that in mind. Every provision has an economic consequence. So when your lawyer is telling you, gee whiz, you should change this language, add this qualifier, add a proviso, do something, the purpose is to shift the economic risk to the other side. That's all a contract is, the allocation of risk. And that's why lawyers spend so much time negotiating contracts, because that's what you're trying to do, is to get the best deal for your client and to make sure your client can manage the risks, understand what the risks are, and can quantify them economically. One area in a contract that creates a lot of issues economically deal with the allocation and prorations. Recordation and transfer tax, the bane of any developer's existence in Maryland. And by statute, they're split 50-50. But contractually, you can shift that if you have the bargaining power. It's unusual, but there's no law saying you can't do it. In fact, the statute says unless the parties otherwise agree, you'll split them 50-50. And be aware of any changes in the recordation and transfer tax regime. Baltimore City, back in January, just adopted a new yield tax that is tacked on to the recordation and transfer taxes in Baltimore City. It's very, very small the way the statute or the ordinance is drafted, but it's out there. So make sure you cover those types of provisions when you prepare a PSA. Rental income, again, this is on income producing property. How are you going to deal with the rent that is being earned on the property? How will they be allocated? How about if there's a delinquency in the rent collection? Can the buyer say, well, if I collect any rent, I don't care if it's delinquent, it's mine to keep? Well, the seller won't like that, but your response to that is, well, seller, you should have collected that rent while you own the property. Don't shift that onto me. So you get into all those types of arguments about rental income. And how long does if you give the seller the right to chase down a tenant, the buyer doesn't want the seller to interfere with his landlord-tenant relationship he's trying to establish. So the seller can't sue that tenant. As a buyer, you don't want that. Maybe they can file a contract action, but you don't want lawsuits flying around. So you try to manage that risk to make sure that the tenants aren't getting upset. CAM charges, common area maintenance expenses, you see that in a lot of income producing property, retail, commercial. Those issues come into play because what happens if there is an audit of those expenses? Who's going to deal with that true up? And so you have to deal with that contractually and allocate that responsibility. Real estate taxes and assessments. Sounds simple enough. Everyone knows how that is dealt with in Maryland. But what happens if there is a real estate tax appeal? It doesn't coincide precisely with your period of ownership. There's going to be a hangover period. How do you deal with that? If there's a refund, who gets it? How is that dealt with? Is there interest earned on it? Who pays the expenses for pursuing the appeal? What happens if the appeal is unsuccessful? What happens then? So those are issues you need to anticipate while you're going through there. There are other issues too that you have to deal with in terms of the economics. How about if there are any tenant inducements? And again, this deals with income producing property. There could be free rent, there could be tenant allowances, there could be leasing commissions that are due and payable. Who's paying for those? So you need to focus on those issues. One point that you don't often see in real estate contracts in Maryland on just a pure purchase and sale of an asset as opposed to buying a business is the allocation between real property and personal property. You don't often see that. Usually the personal property is de minimis, so there's no sense in allocating it. And if you do allocate it, you have to pay sales tax on it, file a sales tax return with the state. That's a hassle to chase that down and get an indemnity from the seller to pay the tax. Who wants to deal with all that? So you usually don't see that. That's just wrapped into the overall purchase price, and it's dealt with that way. Let's talk about the second point. Let's go back here a second. As-is clauses. How many of you have seen as-is, where-is clauses in commercial real estate contracts? You probably see them all the time. You're buying this property as-is, where-is, there's no reps or warranties, you're taking it as-is, do your due diligence. What do you do with those types of provisions? Do you try to strike them out if you're the lawyer? Or do you try to negotiate the provisions? Or do you just say, well, the seller's not going to change the language, so what do you do about it? And I think one of the good things to do is to recognize that caveat emptor is the ruling principle in Maryland. Let the buyer beware. If you're the buyer, you're buying the property as is, where is in a commercial contract unless you otherwise negotiate it. But from a seller's perspective, the seller is saying, look, I'm giving you a time period to look at the property. You can kick the tires all you want, but when we go to closing, I don't want to hear from you again. I just want your money. See you later. And so you negotiate those types of issues. And from a negotiating strategy, do you try to put carve-outs into the language? And I think the most effective way that I found to do that, some of these as-is provisions go on for pages, and they're all in upper caps, they're hard to read, and it's, when will they ever stop? But what you'd like to do, and most sellers don't object to it, is just say, except as otherwise provided in this contract, the seller makes no reps or warranties, blah, 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 and you're buying as is, where is. And by adding just those few words, you can piggyback on any reps or warranties that you've extracted from the seller. So that's how you tie that in together, and it doesn't destroy what the as-is concept is in the purchase agreement. There's a study period. Usually contracts have a study period. Sometimes they can be long, sometimes they can be short. It's purely a negotiation how long those study periods are. They're called due diligence periods, investigation periods. The concept's the same. When you sign the contract, the buyer usually has a period of time known as a due diligence period, and that can range from a couple of weeks to months, depending on what the deal terms are, whether there is provisions in there for pursuing entitlements, doing environmental investigations, geotechnical type work. So those provisions vary greatly. But the key to it is the longer the due diligence period is, the seller is less likely to give representations and warranties about the property. The theory being, look, I'm giving you all this time to investigate the property. Turn yourself loose. Spend all the money you want to. But since I'm giving you that much time, don't look to me to make any reps or warranty about the property. It's not going to happen. The converse to that, and again, this is on a continuum of how this plays out. If you have a really short due diligence period, you tend to get more reps and warranties from the seller. On the theory is you've had less time to investigate the property. It makes sense to do it that way. Where you find where you have real issues is when you have a sign and close contract. And that's when you sign the contract, you're closing. There's no due diligence period. and that's been all the rage in high-profile commercial real estate contracts I've been involved with, is that they put all the documents in a data room. You have a very short time period to look at them, but once you sign the contract, once you negotiate it, you're done. There's no separate due diligence period. So it all depends what the negotiating strategy is, what the bargaining strength of the parties are, how that all plays out. But just keep in mind, the longer the study period, the fewer reps and warranties you're going to get. The shorter the study period, the greater likelihood that you'll get more meaningful reps and warranties. There is a case right down the street, rose right down the street from here in Columbia, about 9 or 10 years ago. And I don't know whether you people remember it, but it dealt with a person who bought some property and found out once they bought it there was a cemetery there, the old poltergeist case. And the buyer prevailed by suing the seller because of a fraudulent concealment. So even though you have all this nice as-is language, it doesn't protect you from fraud. So if you engage in fraud, the courts are going to protect the buyer in that situation. And here, when there was a cemetery on this property that was fraudulently concealed, and the court said that was a material fact. You know, I guess they watched Spielberg's movie Poltergeist, and they said, little people coming out of the woodwork, and they said it's unreasonable to expect a buyer to acquire that property. Had the buyer known about that, the buyer probably would not have bought it. So that's one thing that will be carved out is fraud, obviously. Let's go on to the next one. And this deals with what does a seller know? And a purchase contract typically contains representations and warranties from the seller. Those can be very brief, they could be basically worthless, they could be extensive and meaningful. It all depends what you're able to negotiate. They usually fall into basically two major buckets. One deals with property condition and characteristics, and for that you talk about the leases, whether the property complies with all laws, is there any litigation, are there any service contracts associated with the property, tell me what they are, list them in the contract, are there any leases, and how about the environmental? That's always an area of fertile discussion when you negotiate a purchase contract. You want the seller to give you a representation and warranty about the environmental condition of the property. And if you're the seller, you're saying, look, I'm giving you a study period. Hire your own environmental consultant, do your phase one. I'm not giving you anything. I don't care if I'm sitting on environmental reports. You go ahead and do your environmental investigation. From a seller's perspective, I tend to, and of course the client has to agree to it, it's sort of the open kimono theory, is that, look, if I'm a seller, I'll give you everything I have in my possession, good, bad, or indifferent. Take a look at it, because you don't want any claims later on that you concealed something from the buyer. So that's usually a good rule of thumb, is open disclosure, give the buyer everything, make all your documents available to the buyer, and turn the buyer loose. But on environmental, that's where you typically have a lot of discussion about what is the seller willing to do, go on the hook to give you a representation and warranty about the environmental condition. Has there been are there any USTs on the property? Are there any phase ones or phase twos that the seller has in his possession? Are there any environmental violation notices that have been issued? Maybe they've been resolved, but they could still, there could have been some issue in the past that may be relevant. So those are the types of things you want to think about. And the other thing is too, did the seller grant any options to buy the property to someone else? I'd want to know that if I was a buyer. It may not be of record in the land records, but the seller may have given someone a purchase option in a lease agreement, a letter agreement. You just don't know. So you want to flesh that out by getting that rep and warranty from a seller. Then the other major bucket of reps and warranties deal with entity formation and governance types issues. The seller is in good standing. The seller has the authority to enter into the contract. There's no bankruptcy, and the seller is in good standing under applicable law. So those are areas that you deal with. Another area, in addition to environmental issues that entails a lot of discussion, and again, this is on income-producing property, deals with leases. Let's say you buy a building like this, it has leases in it. Well, tell me about the leases. Are they in good standing? Are there any violations? Are they paying? Are the tenants current in paying rent? And from a seller's perspective, what I tend to do is, here's the list of the leases. Here are copies of them. That's all you're getting. Maybe you'll get an estoppel certificate from the tenant. But as a seller, I want to make very, very minimal reps and warranties about the leases. Maybe you can go talk, as a buyer, you can go talk to the tenant, get a comfort level that way, read the leases, make sure you're comfortable with them, make sure you understand what the leases say. But as a seller, I don't want to go too far on the hook in making reps and warranties about these leases. And again, this is all risk allocation. The seller wants to reduce the quantum of risk that it's facing in these reps and warranties. Because if there was a breach of the rep and warranty, that means the seller is on the hook financially for a breach of that to the extent the buyer incurs damages. So you want to make sure you manage that whole dynamic. The knowledge matrix. And let's just take a typical representation warranty, very simple one. The seller hereby represents and warrants to the buyer that the property is subdivided of record. That's not qualified, that's categorical, it's flat out. There's no ambiguity about that at all. As a seller, if you make that rep and warranty, you better be pretty sure it's correct. There's no equivocation on that one. Now, if you're not too sure about it, if as a seller you think, well, I'm pretty sure it's subdivided. I remember getting a subdivision plat at one point, and if you're in that category, maybe you qualify a little bit and water it down to say, to seller's knowledge, the property is subdivided of record. And as a buyer, you're saying, okay, what's seller's knowledge? And if you're the seller, you're saying, okay, to seller's knowledge without inquiry. And again, you're just asking the seller, to your knowledge, you tap the seller on the shoulder, is the property subdivided? And the seller will say yes or no. That's the knowledge you're getting when you have that language without inquiry. And if you further qualify as a seller, you can say to seller's knowledge, which knowledge is limited to the current actual knowledge of seller, the property is subdivided. Well, that's a lot of weasel words. Hey, what are you getting from that one? Not much, but it's important because if the seller is a corporation, a large company, when you have the word knowledge in there, you're imputing the knowledge of everyone in that entity, from the janitor to the CEO, the entire spectrum. And so that's why you want to limit it to a specific individual if you're a seller. And the way you do that is you say it's limited to the current actual knowledge of Jane Developer, the officer or seller responsible for managing the property for the last 3 years before the contract was signed. And that is very discreet, that's very isolated, and that's how you manage your risk if you're the seller, and making sure that when you make this rep and warranty, that you can stand behind it. Jane's been associated with the property for the last 3 years. Jane knows the property. Jane's not going to go talk to everyone, but Jane is probably the right person to make that rep and warranty if you're going to rely on her knowledge. So that's how a seller manages that risk. Now, of course, a buyer is going to push back on that and say, what value is that? It is so diluted what you're giving me. But as a seller, the response is, I recognize that, but at least you can rely on it. It's factually accurate. This person who's been the person associated with the property for an extended time period, is a prominent person in this organization, is saying that property, to her knowledge, is subdivided of record. So maybe you let it go at that, but that should usually take care of it. Let's go on to the next one. And this deals with an issue that I see all the time. The lawyers spend all this time negotiating these reps and warranties. They go on for pages. They're qualified, just as we saw, to seller's knowledge, without inquiry, and it just goes on for pages dealing with that. Then you go to closing, you think you have a good contract, and the buyer discovers after closing, the seller lied. The rep and warranty is just false. And the buyer is upset, and the buyer says, well, I'm going to sue the seller for damages. I have damages because I relied on it, and I've incurred X, Y, and Z damages. I'm going to file a lawsuit against the seller. Well, guess what? The seller's long gone. The seller was a single-purpose entity. It was a Maryland LLC, this was the only asset it had, and when it got paid the purchase price at closing, it distributed the proceeds to its members, and they're long gone. So what do? You've negotiated all this nice language in the contract. There's been a breach that you discovered post-closing, and you have damages. You want to sue the seller, but there's no money. There's no money. So how do you manage that? And that is an issue that buyers and sellers grapple with, usually at the last minute when the buyer wakes up to the fact and they realize that the seller is a special purpose entity with no assets other than the real property. And what do you do if you're the buyer? Well, from a buyer's perspective, you want to do a couple of things. One is you want to make absolutely sure there's liquidity in the entity. And if the entity doesn't have liquidity, you want to make sure there's something you can go after that is liquid. And there are a number of options, or there's a menu of choices out there that a buyer can look to. One is nothing. The seller can tell you go pound sand. The seller can say, look, I'm a reputable seller. I stand behind these reps and warranties. My reputation will be damaged if I breach the rep and warranty. The commercial real estate industry is a small community, and word travels fast. And if I breach a rep and warranty, that's going to damage my reputation, and the next buyer I run into, they won't want to deal with me. So, just calm down, buyer, and I'm going to stand behind this, but I'm not going to put any money behind this. Sometimes that plays out. It deals with the bargaining strength of the parties, the type of the transaction that you're dealing with. Is it a fee transfer of property, or is it an entity interest transfer? What's the cost involved of this, what we call credit enhancement? Is there a letter of credit fee? Are there premiums for any insurance product you can get to protect yourself? And what are the nature and scope of the representations and warranties? Are they detailed? Are they extensive? Or are they just bare bones? If they're bare bones, maybe you don't want to spend a lot of time negotiating this liquidity issue. Going down the spectrum here, how about a cash escrow? That sounds good. As a buyer, you tell the seller, look, we'll pay the purchase price, but I want X dollars segregated from that for a certain period of time to be held in escrow. And if something pops up post-closing, that's the pot of money I'm going after. Well, the seller's going to say, no, I want my purchase price. My investors want their purchase price. No, that's not going to work. Okay, so you go back to the drawing board on that one. Well, how about a letter of credit? Well, that sounds good. Letters of credit have liquidity. Escrow agent can hold the letter of credit, or the buyer can hold it. And if there's a claim, you can draw on the letter of credit, making sure that the draw conditions are satisfied. Maybe that's a good way to do it. But there's an expense to it. The seller's going to say, look, it's going to cost me X dollars to get a letter of credit. That counts against, the bank will want security for that. And we're back to where we started from. I just don't want to tie up my capital for something like this. And the seller says, I'll tell you what, how about if I give you a guarantee? I'll give you a guarantee from a credit-worthy entity. Maybe it's a parent company. Maybe it's an individual with deep pockets. Who knows what it is? And from a buyer, be careful in taking the bait on that one, because you have to do your underwriting on that guarantor. And that's going to take time. It's going to take some expense to do that. And if you think that if there's a claim post-closing and you have damages and you need to go after the guarantor, you think the guarantor is just going to write you a check on your demand? And that's not going to happen. There's going to be a lawsuit. The guarantor is going to resist paying the claim because of X, Y, and Z. There's not a breach of the rep and warranty. Who knows what defenses they'll raise. But the liquidity in a guarantee situation is not as apparent as you think it would be. So be careful about a guarantee as being a sort of the saving grace on that one. There is a product that's provided in some transactions. It's called rep warranty insurance. You don't often see that in commercial real estate transactions. You see it in M&A transactions quite a bit. But there's a whole series of issues you have to deal with if you're trying to get insurance to backstop these reps and warranties. One idea that we've used in the past too is if you're the seller saying, look, I promise to maintain a certain net worth. I promise to keep X dollars in reserve until these issues are resolved, this time period goes past. And you're saying as a buyer, well, that's fine, but where are you going to keep the money? You going to keep it in a bank? Am I going to be jointly named on the account? How's that going to work? And how am I going to police that if I'm a buyer? So the point is there's a lot of different options out there. Each of them have their own pros and cons. There's not a magic bullet to this, but this is an area that is hotly contested in negotiations. Then you'll run into some sellers and some buyers. They're going to say, what's the point of negotiating this type of issue ad nauseum? How often has that ever come up in your career? And if you talk to commercial real estate lawyers who've been around the block a few times, some have never run into this issue about actually suing a seller for damages for a breach that's discovered post-closing. It just doesn't happen. I think in my 30-some year career, I've seen it happen once in one of my transactions. It was resolved very quickly, but they tend not to happen. Then, since you're paying our fees, you're saying, why do these lawyers negotiate these things? It just drives me nuts. And the reason is, there's a purpose to it. Because you want to make sure the seller stands behind these reps and warranties. There's a dissuasive effect in having a seller go on the hook financially to stand behind these. And the seller, I think, because of that, makes sure that the reps and warranties that are being provided are factually accurate. And that's why you don't see too many claims, because the seller's not going to lie if there's money on the hook there. At least that's my theory. Survival periods. Has anyone heard of survival periods in commercial contracts? Yes, no, maybe? The seller reps and warranties, if you don't have this type of provision in the contract, any provision in a contract when you go to closing and a deed is delivered from the seller to the buyer, every provision in that contract disappears. It no longer exists. Period. Full stop. And that's why lawyers negotiate language in commercial real estate contracts to have certain provisions survive the closing. You've probably seen that language in your purchase and sale agreements. This provision or this chapter or this blah, blah, blah survives closing for a period of X days, X months, X years, whatever it is. And that's the reason why, because if you don't have that type of provision in your purchase and sale agreement, once that deed is transferred, that contract no longer exists. The reps and warranties that you negotiated, they no longer exist. If there's a breach of those reps and warranties, you can't sue anyone. They've all merged into the deed, and that's called the merger doctrine in Maryland, and that's alive and well. So lawyers and their clients spend a lot of time negotiating the survival period to make sure that there is recourse by a buyer against the seller post-closing, to make sure that if there are any breaches of reps and warranties and damages arising from them, that the buyer has recourse. Let's say a broker comes out of the woodwork and says, hey, I was entitled to a commission on that sale that closed last week. Who's paying me? And there are reps and warranties that separately deal with brokerage commissions to protect against that. There may be post-closing true-ups, like on common area maintenance expenses, that you'll need to true up after closing. And that's economics. There are dollars to be paid by someone in that situation. So you want those provisions to survive closing. And what's the survival period? Typically in commercial real estate contracts in Maryland, you see anywhere from 6 months to 9 months, sometimes 12 months. Sellers obviously want to keep that time period shorter rather than longer. Buyers have the opposite incentive to keep them longer. But keep in mind that the longer you have the survival period, the longer the post-closing credit enhancement that we just talked about will have to remain out there. And the sellers don't want to keep their capital tied up or their exposure out there for an extended time period. What you also want to make sure too, when you have a survival period, let's say it's 6 months, you want to make sure there is some time period to file a lawsuit after that period ends. You just don't want to be forced to file a lawsuit on the last day of the survival period. So you usually tack on a couple months or 30, 60 days for that. And also, just to bore you to tears on this one, you can have different survival periods for different provisions in the contract. And this is important. If Maryland, we used to do this quite a bit before the recordation and transfer tax statutes were amended years ago dealing with controlling interest, but used to buy and sell partnership interest in a partnership or LLC interest in an LLC. And you could avoid recordation and transfer taxes years ago by doing that. That's been clamped down basically based on the revised statute. But in that situation, you would want to have the statute of limitations very, very, very long when you buy these member interests, because that's what you're buying. You're not buying the real estate, you're buying the member interest in the entity. And those survival periods should be very long, because you may not discover there's an issue until way down the road. But there are different ways of handling that to have different survival periods for these provisions. And people tend to negotiate those in good faith, and they don't seem to be a problem. Performance periods, timing periods. Again, you have a contract that's real long. You have due diligence periods. You have closing dates. You have a title and survey review period. You have a deadline by which you have to report any issues on due diligence. You have a pre-closing time period to prepare a closing statement. There are all sorts of time periods flying around in a contract. Make sure you know how they work together. Just don't assume that all these time periods somehow magically come to work together. They often don't. You need to sit down, close the door, map out the dates, and to figure out exactly, make sure these dates work. For example, in the due diligence period, I see all the time contracts say that the title and survey review period, the buyer has the right to review title and survey up until the end of the due diligence period. Then the buyer has the right to submit objections to title to the seller. Now, from a seller's perspective, that doesn't work. And why doesn't it work? Because you want everything, all the due diligence confined within the defined due diligence period. 60 days, 90 days, whatever it is. Title, survey, environmental, everything else. You don't want these time periods to spill on beyond that, because that extends the lack of certainty about whether you have a deal. So keep in mind that these time periods have to work together, and if you have a due diligence period, make sure all the contingencies, all the back and forth on title and survey, environmental, are all within that defined time period. Don't have any spillover, because that's going to create a problem, because the seller will think it has a deal, the buyer's locked in, the due diligence period has expired, you think you're going to closing, then the buyer says, oh, we have these title issues that haven't been resolved, we have an additional time period. You don't want to hear that, and I can tell you right now, your client doesn't want to hear that. So make sure these time periods work well. And what we usually do too is once the PSA, the contract is signed, the parties agree to what the critical dates are. There's a matrix, you send it around, everyone signs off on it, everyone knows what the dates are. There's no guessing game. You take into account if a day falls on a weekend or on a holiday, it spills over to the next day, that's not a holiday or a weekend, and everyone knows up front how these time periods will work. And that way you avoid issues down the road. There is something you may run into infrequently, but it's out there, and that can affect timing dramatically. Let's say you're an investor, you're buying some raw land here in Maryland, and you have foreign investors in your fund that's buying real estate. And let's say the real estate that you're buying is raw land right next to NSA headquarters in Fort Meade. If you have a foreign investor in your entity that's buying that type of land next to a national security site, that could trigger a federal law called the CFIUS rule, and that's the Committee on Foreign Investment in the U.S. And that is a sleeper that may come back to bite you if you're not sensitive to it, because you have to go through that process. And that's a federal process where you submit your transaction, the details of who your investors are, all the way up the chain, so they know exactly who's buying the asset. The federal government knows exactly who's buying the asset. And the committee is comprised of representatives from Homeland Security, the State Department, Defense Department, and others. And it's actually a committee that meets, and they evaluate and scrub these transactions to make sure there are no national security implications. I had a transaction in DC a couple years ago where my client was selling property, a portfolio of office properties, and one tenant in the office building was a DoD entity. And I think it was the F-15 Strike Force Eagle crowd or something. It sounded pretty impressive. The buyer who was buying this asset, there were two sovereign wealth funds, one from Singapore, one from South Korea. And they were buying an asset in a building where the DoD had some very highly sensitive operations dealing with national security. And we had to go through the CFIUS process on that. And that adds a considerable time period to transactions. I'm talking 60, 90 plus days that are out there, and you can't make the process go faster. And we found out on the last day when the government was supposed to get back to us whether they were going to approve it or they had the right to extend it. Well, guess what? They extended it for another time period. And we had to sit around, the buyer had to sit around, just drumming your fingers, making sure market conditions don't change. So you have to be careful about those types of provisions that are out there. And David talked about the black swans. Something like that you're not really thinking about. You have an investor in your group, foreign investors, they're buying some property, no big deal. Be sensitive about that if there's some national security issues involved, because that could come out of left field and really delay a transaction dramatically. And there's no guarantee that the committee, the CFIUS, will approve the transaction. And guess who has the ultimate authority to approve or disapprove the transaction once the committee's weighed in on it? The President of the United States. By statute, the President has the right to either approve it or disapprove it. And under President Obama, he did disapprove a couple of transactions. So just think about that. The transaction is about ready to close or has closed, worst case scenario. You have to, if the President later disapproves it, you have to unwind the transaction. Just think about that, trying to unwind a transaction that's closed. That just makes your head spin to think about it. But let's talk about more pleasant stuff. Damages for a pre-closing breach. And we've all seen this. If the seller defaults pre-closing, you haven't gone to closing yet, and the seller defaults, what do you do? And you can say, well, gee whiz, what's the remedy that I have in that situation? One remedy is specific performance. And you can sue the seller for specific performance to force the seller to close on the transaction. Maryland recognizes it. It's a valid remedy. Sellers will push back on it, but they shouldn't push back on it because that's one of the few remedies that you have as a buyer to make the transaction go through. And look, you negotiate the purchase sale agreement in good faith, you've agreed on the terms, and you're proceeding to a closing, and the seller says, oh, I've changed my mind, I want to sell it to someone else. Not going to happen. And that's when you file a suit for specific performance and go from there. Now, how about a buyer? If there's a default and the buyer's incurred all these due diligence expenses, environmental consultants, lawyers, engineers, geotechnical engineers, all of this money has been spent during the due diligence period, and the seller walks out on you. Well, what happens then? Do you get your deposit back? Obviously, you get your deposit back, but what about your out-of-pockets? You should get your out-of-pockets back at a minimum. You spent the money, you did everything you were supposed to do, and the seller just defaulted on you, sort of flaked out. So what are you supposed to do? We'll negotiate that you'll get reimbursed for all your out-of-pockets. The seller will come back and say, I'm not writing a blank check, I want to cap it. So you go back and forth, that takes time, you negotiate what the cap is, and you have to make sure the seller has the money, so you have to have those discussions. So that's how you typically resolve that issue, is put a cap on those due diligence expenses. The other thing too is if there's a default, the seller may say, look, if there's a default, I want all your due diligence materials. And as a buyer, you may negotiate that and say, okay, maybe if you pay me for them, I'll give them to you. The other issue too, if you're a seller, don't automatically have a knee-jerk reaction that you want all the due diligence materials from the buyer. There may be something in those materials you don't want in your files. Let's say there may be environmental issues with the property. Do you want those in your file as a seller? Maybe not. So be careful. Don't automatically assume that if there is a default and if you're the seller, you say, look, I want all those materials that you've generated, buyer, during your due diligence period, I want all those into my files. I want the title, I want the survey, everything else, including environmental. Okay, be careful what you wish for.
So what's the ramification? You're the seller, whether you know there's environmental issue or you don't know there's environmental.
Yeah, let's say you don't know maybe you've heard noises that there's an environmental issue with the property. The problem is on the next transaction, let's say this deal doesn't go through, the next transaction the buyer is going to say, give me all your materials in your possession. Then you're stuck there with a damaging environmental report. What are you going to do with it? Yeah, you can push back and say, no, you do your own environmental. I'm not giving you anything in my files dealing with that. That's one way to do it, but you also have the fraudulent concealment issue you have to deal with.
In commercial, do you have to disclose the types of things that you have to do in residential, for instance?
Not typically, no. It's pure caveat emptor. The Chesapeake Bay, there's that type of generic disclosure, forestation issues. But in terms of environmental issues, no. It's buyer beware in that situation. Let's go on to the drafting of closing documents. Look, a purchase and sale agreement goes on for all these pages, looks like a mini book. Then you have the exhibits. And you're saying, why you spend all these time putting all these exhibits on there? The form of the deed, the form of the assignment of leases and rents, assignment of service contracts, the FERPTA affidavit. Why are you spending all the time and money doing that? And the reason is, that's the best time to do it. The deal is fresh in everyone's head. You can agree on the form of the documents up front. There should be no conflict between what you negotiated in the body of the contract and what's in these form documents. And this is the best way to flesh out any issues. And you can avoid a lot of stress too, because if you put this off until the week before closing, it could be months later, you forgot about the details of the deal, or you're going to attach the right documents to these exhibits. Who needs all that? So just while you're involved in the throes of negotiating the purchase and sale agreement, just agree on the form of these documents. And you want to make sure these documents are in sync with each other, because you may have negotiated some great indemnification provisions, survival period limitations in the contract. Then when you get to the closing documents, they may be silent on the issue. And you have some ambiguity, you have a potential conflict. And what do you do? And I've seen this happen quite a few times. If you have no mention of a survival period in the closing, in the form of the closing documents, what does that control over what you negotiate in the PSA? What happens there? So you want to make sure there's coordination of all those documents to avoid those types of unpleasant surprises. David talked about option contracts, and this is one of my favorites, the conditions precedent to closing. And it's somewhat surprising when you look at a seller's form contract, sometimes you don't see this provision. What happened to it? Did it disappear? It sort of magically disappeared. It should be in there. And every other provision's in the contract. And from a seller, the seller doesn't want these conditions precedent to closing provision in there. The seller says, look, I've agreed to sell you Blackacre for X dollars on a certain day. When we go there, that's what will happen. That day comes, I want that money. And if you're the buyer, you say, whoa, wait a second. I want to make sure that when I go to closing, that you've lived up to your obligations on the contract. I want to make sure that the title that I've negotiated for will be delivered to me at closing, that I'll get the form of the title policy I want. I want to make sure that the reps and warranties that we spend so much time negotiating are true and correct in all material respects. I just want to make sure that what I've negotiated will be delivered on the closing day. And that's why you have these conditions precedent to closing, these closing conditions. You spend a lot of time too negotiating how these provisions will be drafted. And you run into a tension between at what point does a breach of a closing condition morph into a default? Is it a failure of condition, or is it a breach of default? I mean, a breach of a contract and it's a default. And the remedies are very different, starkly different. If it's a failure of condition, too bad, the contract terminates and everyone licks their wounds and walks away. Compare that to if it's a default, the seller is exposed to damages. So you spend a lot of time negotiating what is a failure of condition versus a default under the contract. So you need to spend some time doing that. There are some conditions to closing, like condemnation. Seller has no control over that. So that's a failure of condition. You made a representation day one, there's no condemnation. Well, guess what? Day 15, the state come out of the blue, files a condemnation action. And when you get to closing, that representation warranty you made is no longer correct. You can't say there's no condemnation. And that's when you get into the failure of condition. So you negotiate that provision to make sure you don't get caught in the switches. Things that you can't control, that's usually a failure of condition from a seller's perspective. So just be mindful of that. From the title perspective, you spend all this time negotiating the title, that you'll get title with just a defined set of exceptions to title. in the survey, nothing's changed there. You want to make sure when you go to closing that you'll get the title policy that you negotiated with the endorsements. You don't want to get to closing and to find out the title company says, you know what, there's something that appeared on title, that's going to be an exception to your title. Well, the buyer's not going to like that, and your lender is not going to like that. And how do you deal with that? Is it a failure of condition? Depends how it arose. The last one, I'm not going to spend too much time on this because this deals solely with income producing property, but I just want to mention it so that you're sensitized to it. Let's say it's an office building, a retail center, industrial project. You have tenants. The seller has tenants in the complex, in the asset. And one way that a seller manages the risk of making a lot of reps and warranties about leases is to foist that off onto the tenants through what they call tenant estoppel certificates. And that's where a tenant is required under the terms of its lease to make certain factual representations to the seller and to the buyer and to the buyer's lender about certain aspects of the lease. Is there a default by the tenant? Is there a default by the seller? What's the amount of the rent? What's the length of the lease term? Are there any tenant inducements that have not been provided? Or are they still out there, like free rent, tenant improvements, leasing commissions? So these things really work to a buyer's benefit. And usually you attach the form of the estoppel certificate to the contract, so there's no negotiation about that. Sometimes the lease contains its own form of what the estoppel certificate will look like, so you rely on that. And sometimes with major tenants, they only have one form of estoppel certificate, and it's take it or leave it. Starbucks is famous for that. It just has a very basic estoppel certificate, and if you don't like it, too bad, this is all we give. And it is bare bones. There's some math I won't go through, but you got to be careful when you negotiate these estoppel provisions that you understand the way it's calculated. Because sometimes a seller says, look, I'll give you tenant estoppel certificates from tenants occupying 65% of the space in the building. Well, you got to be careful what the 65% is. Is it leased or leasable? And that can make a big difference in terms of what tenant estoppel certificates you get. The example I have here is, if that is true and you get the estoppel certificate from the smaller area tenants, you may not get an estoppel certificate from the biggest tenant in the asset. And that's not right. And your client will be very upset to learn that. So usually you have a major tenant requirement. Major tenants are required to give estoppels, and a certain percentage of non-majors are required. And you get into a lot of discussions about the tension. The sellers, they want to keep the estoppel requirement as modest, as bare bones as possible. The buyer wants a very robust tenant estoppel requirement to make sure that it's getting all the information it needs. So you have those fights going on. And the other thing is, let's say you have an estoppel certificate and you get the estoppel certificate day one, the seller does. The seller gives that to you. Closing doesn't occur for another 2 months for whatever reason. Well, the time 2 months rolls around, is that estoppel certificate stale? Is it still good information? And the sort of the market right now is 30 to 45 days. 45 days is getting a little bit long, but a tenant estoppel certificate is pretty good for 30 or 45 days. Sellers won't, you'll say, well, if it goes beyond that 30 or 45 day period, seller, go back and have the seller, have the tenant give a new estoppel certificate or refresh it. And if you're the seller, you're saying, look, I went to the well once, I'm not going to go back to the well twice. And what happens if some information has changed in the interim? What happens if the tenant says, look, I'm only required to give one a year? Too bad. So you need to manage that issue too. Some transactions, I have one client who will get the tenant estoppel certificates day one, have them provided to the buyer, and you're closing. It's a sign and close contract. You have everything prepackaged, there's no negotiation, it's right there. And that's extremely aggressive, but on some hot properties, you can get by with that very aggressive behavior. But that's it. The key is follow the money, going back to point one. Keep your eyes on the money. It's easy to get lost in the weeds dealing with these contracts, but always keep an eye on the money. It's extremely important, obviously. With that, Dr. Thaler.
Questions that I can have. The typical land development contract is you buy a piece of property, typically raw, and then take it through a process to get a series of
Right.
entitlements, and then when it's ready to go, you close. Can you share with us your wisdom in what should be in those contracts, what to be careful for? And then I have one second question. Is the big issue in land development, in all land acquisition contracts, seems to be toxic and hazardous waste, CERCLA liability.
Right.
Could you comment on how to protect yourself from CERCLA liability?
Yeah. On the first point about the land sales contracts, one thing that we spend a lot of time negotiating is to make sure that the triggers for taking down the land, or the trigger, what types of entitlements that the buyer is getting or the seller has to get, are very specific and not subject to ambiguity. You know, the last thing you want to do is to get into a disagreement with the other party about what does that condition mean. You said you're supposed to get a certain type of permit. Is it final? Is it non-appealable? Is it just a permit that's been issued? It could be appealed later. Be very specific about what type of permit is required, what type of zoning or land use approval condition that you're trying to seek that will trigger a particular obligation. Then there's no time for ambiguity. And you have to know what the zoning ordinance provides, the zoning requirements, work with your engineer, work with your zoning people to make sure you identify with specificity what those triggers are. Because I've seen it happen before where you get into situations and people say, well, no, you know, I didn't get this particular permit. It's still subject to appeal. The appeal period may be lengthy. And what happens if that's appealed to a higher court? Do you have to wait around? So be very specific about those types of situations and how those scenarios will play out. It's not as simple as it first appears just to say, I'll get this certain type of zoning classification. Make sure you understand what it is and what the permutations of that could be.
Well, I would just jump in on that. We have a matter right now with your office, actually. The contract says the buyer has to close at record, what it says. The buyer thinks at record means fully entitled when permit's ready to go, and the seller thinks at record means when there's a record plat. And it's and that's exactly what you're...
That's the ambiguity that you need to avoid in drafting. And I hope we didn't draft that, but who knows? We'll talk to our carrier about that one. On the CERCLA liability, look, if you're a buyer, you certainly want to get your Phase 1 environmental site assessment, and whether the property is amenable to some type of brownfields development, or whether you can get some type of letter from the state saying that you can develop it with these certain types of controls. That may be important.
Let's just say it's a cornfield. It looks like a cornfield, and you want some reps. We see tussling over this go on all the time. You want some sort of a rep from the seller, and the seller doesn't want to give much of a rep as to what may be there. What's your advice on that?
Yeah, if I am the buyer, I want to get my own environmental site assessment done because I get the protection under federal and state law by getting that. And you don't want to rely on a seller's Phase 1 that may be dated. You can only rely on them if they're within a certain vintage. I think it's 180 days, they have to be current. So I think it behooves you, if you're a buyer, to get your own Phase 1, go through the process, understand what the limitations are, and if there are any issues. From the seller, if it's your cornfield that you're talking about, maybe an extract a rep of warranty about the use of pesticides, herbicides, farming activities, what have been done there, any dumping. But that's what I would do there. It's getting late. Any questions?
Yeah, I need to hear you say a word a little slower. You were saying it quickly. Is it nociferous?
OSIFIUS?
Osifius?
Yeah, Committee on Foreign Investment.
That word?
Yeah.
Just explain it again.
Yeah, the Committee on Foreign Investment in the U.S., and that is if you're a foreign investor and you're buying U.S. real estate that could implicate national security concerns, you have to go through a process. You have to submit the transaction to the Committee on Foreign Investment in the United States, which is based in Washington, D.C. And they have their own staff. and you pay a fee to go through the process. And I would strongly advise you that if you trip that wire, make sure you get someone, engage someone who knows how to go through the CFIUS process. It's complicated, and there are a lot of traps for the unwary, and you really truly need someone who's been through it a number of times. Yeah, go
So
ahead.
if one is acquiring land after the, call it initial entitlements, because it's not fully ready to build on, and finishing up the development, and you have this, if you would, take down approach, when is closing? Is closing when the, if you would, let's say it's a multi-lot deal, is closing the first lot? And if so, what do you call that period between when the first lot is purchased and the last lot is purchased?
Right.
What do you call that time period?
I don't know if there's a legal word for it, but I view that as a staged or sequenced closing timeline.
Okay.
The first closing is day one. You take down X number of lots for a certain purchase price. There's a time period that elapses until the next set of conditions are satisfied. You close on that sequentially. Number two, in the definition of closing date in the purchase agreement should be sensitive to identifying how that's characterized for each closing. It should lock into that. So I think that's how you can draft around that issue
Okay.
on sequential closings. And I've done that too on portfolio deals. When you buy properties and there are different closing dates, you define what the sequence is for doing that.
The whole estoppel thing, can you just define what that word means and also give me a real-world example of what a estoppel certificate is like?
Yeah, estoppel certificate. Estoppel means that the giver of the certificate is precluded from taking a contrary position. They're stopped from, let's say the tenant says the lease is in full force and effect. That's day one. The tenant makes that statement in an estoppel certificate. Day two, the tenant can't say, oh, the lease is not in full force and effect. That's not right. The tenant can't do that. The tenant is precluded from taking a contrary position later on. And the value of the estoppel certificate is that the tenant is telling certain parties, the seller, the buyer, the lender, and others, that these are the facts dealing with the lease as set forth in this certificate. And if they're incorrect, as a tenant, I can't deny that those were incorrect statements. I can't do that. I'm precluded from saying that. I can be sued as a tenant for making incorrect statements on that estoppel certificate because there is detrimental reliance by others on the accuracy of those statements.
So in the real world, the buyer is looking for a tenant to say, I have a lease that's good for 12 more months in the building, and I'm representing that to the buyer that that's what I'm doing.
That's right.
The buyer's relying on it, and just in a real world example.
That's right. And if it turns out the lease,
I know I got this guy for another 12 months.
that's right. And if it turns out the lease is only for 6 months, there's an issue.
And the issue is against the tenant who makes that claim.
That's right. And separate,
The seller is not in that transaction at all.
no, the seller's not,
Okay.
but the seller may make independent of that representations and warranties about the leases themselves. And there may be a rent schedule that's attached to the contract that has what the length of the term is. As a seller, I wouldn't do that.
Certificates also that the seller is doing, or
What's that?
is the seller making estoppel certificates, or just
Well,
the
This gets a little bit complicated on seller estoppels, which I think are worthless,
Okay.
basically. Let's say that you have an estoppel requirement of 65% on the example I gave. You only get 55% as the seller. You only get 55% of the estoppels back. What do you do about that 10% gap? Some buyers are willing to accept a seller estoppel to bridge that difference. But as a buyer, I'm saying, what value is that? Because I'm not getting that information from a tenant. I'm getting from the seller who refused to give me that information day one. And what am I going to do if it's wrong? Am I going to chase down that seller post-closing if it's incorrect? And we get back into the recourse. What recourse do you have against the seller in that situation? There may be an empty pot of gold there. Any other questions? Well, thank you for your time. I appreciate it. Oh, thank you, thank you.
Yeah, thanks.